Hey, it's your girl Duchess this afternoon. Doing an update on the YSL case. I'll be right back, just giving a little time for everyone to come in. You guys are going to hear a little echo, just doing a little audio check, making sure that I'm live and my
You guys are
audio
going
is
to hear a
working.
little echo, just doing a little audio check. Making sure.
All right, all right. Hey, YouTube, it's your girl Duchess coming to you live. Not giving up on this live stream and saga of mine, not by any chance. So, court resumed today in the YSL case. The new judge took over, and there was not a recusal. In fact, she sent a clear message. I think I may like this judge, y'all. So, let's get into it. Our first order of business is a couple of updates from the trial today. Brian Steele did not hold back any punches. He cited case law today, entering one motion or asking, basically, he was asking the judge to consider, and this was a huge motion, y'all. So today, when they resumed, it was just kind of like an update for the judge. It was only the attorneys there. The jury was not present, nor were the defendants present. It was just the attorneys and the judge bringing her up to snuff on the case, as well as her sending down some clear orders and some guidelines. So Brian still opened us up with case law stating that once a motion for a judge to be recused is entered and accepted by an attorney, by a judge, which it was, and it was signed, then all testimony after that, everything after that, has to be wiped out. It has to be squashed. So he asked the judge to consider that, and he gave very clear case law regarding that. So what does that mean? That means that if she considers the law regarding that situation, regarding that motion, it wasn't really a motion. It was just kind of like something for her to consider. If she accepts that and considers what Brian Steele proposed, then Lil Woody, YSL Woody, I'm saying his name, trying to say his name correctly. All of that testimony from the first question. How old are you? My age. That's not exactly what he said, but that entire testimony is wiped out. And including the recording of him, his interrogation film that was entered, that whole thing, that gets wiped out. So that was just interesting, just in the beginning. He also entered a motion that will be considered. And we're going to slide on over to Twitter and take a look at that motion, because Brian still wants these DAs removed off of the case. Y'all, this court is heating up and it looks like she's going forward. And I'm here for it. I am here for it. So without further ado, we're going to read that motion, and then we're going to get into some of her housekeeping items that she presented today that gives us a clear sign that this lady is not going anywhere. She is going to hear these cases. So let's slide over to this motion. All right. So this is from Thugger Daily on Twitter. And this was the motion entered today. Motion to disqualify lawyers Love and Hilton. State of Georgia versus Jeffrey Williams defendant, that is Young Thug. and the new judge, Judge Whitaker. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files the motion to disqualify lawyers Love and Hilton in the above referenced case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all crimes in the above referenced indictment. As previously asserted, Lawyer Love and Lawyer Hilton have made themselves critical witnesses in this case, including but not limited to when Lawyer Love engaged in text messages with witness Archelian Bennett, and Lawyer Love, Lawyer Hilton, and Judge Glanville communicated with sworn witness Mr. Kenneth Copeland at a critical stage of Mr. Williams' trial during the now infamous June 10th, 2024, wholly improper ex parte in chambers meeting. Undersigned counsel has the duty to examine Mr. Copeland, Lawyer Love, Lawyer Hilton, and Judge Glanville. Y'all, what does that mean? He is going to call these people to the stand on all facets of this secret strategy session, pursuant to Confrontation Clause. Let me just make sure that this is showing up for you guys. It is. Confrontation Clause, right to present a defense, 6th and 14th Amendments rights to effective assistance of counsel, due process, right to a fair trial as well as fair tribunal on behalf of Mr. Williams under both the Georgia Constitution and the United States Constitution. This will mandate that Mr. Copeland be cross-examined before the jury about his meetings and conversations with Lawyer Love, Lawyer Hilton, and Judge Glanville. This essential questioning injects the veracity and credibility of lawyers Love and Hilton and Judge Glanville. Undersigned counsel will also examine Lawyer Love, Lawyer Hilton, and or Judge Glanville as to why they knowingly made false and misleading assertions to Mr. Copeland about the alleged disloyalty of Mr. Copeland's lawyer, and provided legally incorrect information to Mr. Copeland in order to persuade Mr. Copeland to testify against Mr. Williams. Based upon their own deliberate and intentional concealed misconduct, Judge Glanville's lawyers, Hilton's and Lawyer Love's credibility and acts are now at the center in Mr. Williams' trial. These lawyers must be removed and disqualified from further participation in the case, save as witnesses. See Georgia Rules of Professional Conduct 3.7a, LaValle versus State, Martin versus State, Stewart versus State, Schaff versus State. During the jury charge, it is expected that this honorable court will be asked to instruct the jury as to suggested pattern jury instructions as follow. The court has no interest in this case. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, just making sure I'm on track, y'all, or upon the guilt or innocence of the defendant. Undersigned counsel requires this above testimony from lawyers Love and Hilton and Judge Glanville in order to have the deliberating jury consider whether Judge Glanville was, in fact, biased for the prosecution, that this jury instruction is not applicable prior to July 15, 2024, the day Mr. Williams' motion to recuse Judge Glanville was granted. Wherefore, Mr. Williams respectfully requests a hearing on this motion at the conclusion of same, asks the Honorable Court to grant the above requested relief this 18th day of July 2024. Respectfully submitted, Brian Steele and Keith Adams. Y'all, this thing is heating up, guys. Look, I'm all overzealous. I don't know if it's really heating up or not, but I am excited to see this thing move forward. So there are two things already for Judge Whitaker to hear. One, is she going to follow the law regarding the recusal granted of Judge Glanville? Because with that recusal and that piece going forward, then all of YSL Woody's testimony plus the interrogation evidence will need to be removed, and the jurors will have to strike that from their memory and their notes. That's a huge win, should she grant it. That is a huge win, should she grant it. Oh, and what will that look like if she rules on this motion to remove these two DAs from this case? I probably should have saved that for last, but I couldn't hold it. I just couldn't hold it. So let's get into some of her housekeeping items. Um, you guys, I like this judge so far. She was much more calmer than Judge Glanville. She seemed fair. She had the tone of, listen, let's try to get this together, and we'll survive this. Oh, that means I won't make the judges convention this summer. So when she said that, I was like, oh, she's not recusing herself, she is going to hear it. But she was very fair. um she took a few shots. She took a few shots at the prosecution team in terms of some of her commentary. Like she said, I haven't really followed this case, but when she was talking about moving things along and not submitting multiple pieces of evidence, cumulatory, what they call cumulatory evidence, that was clearly a shot because that's what they've been doing this whole case. So let's get into some of her housekeeping items because she has some things for them to consider. First of all, court will begin promptly at 8:45. She said that means that I will be taking the bench at 8:45, not 9:15, not 9:30, and she expects for all parties to be present and ready to go at 8:45. She mentioned that if a defendant had multiple lawyers on their case, that she will proceed with at least one of them. She doesn't require all of them to be there to get started, but she will not be upholding court. And court will go on from 8:45 to 6 p.m. No exceptions. We want to move this along, ladies and gentlemen. We want to respect the time of our jurors. So everything will be prompt and it will be some long days. They may consider a half a day on Friday for all of the other parties, but they will be there on Friday and use that time to kind of catch up on things that they must hear. Oh, I like that. She said, food in the court and drinks. You can have drinks, as in a water bottle or something for you to sip on. That is totally fine for court decorum. But there will be no snacks, no eating unless they are working through lunch. She got on the defendants. Some of the wardrobes, the sheriffs and the deputies are complaining that the wardrobe closets are out of hand. They have so many clothes in their closets. So she said, I understand they want to have fresh and new outfits every day in court, and that's totally acceptable. But 5 to 7 outfits should be sufficient. You guys can switch them out, but I'll need you to clear that out. Minimizing disruptions in court, she expects for everyone to be on their professional behavior in accordance to whatever their like governing body is for attorneys. No unprofessional conduct will be tolerated in the court. No AirPods or accessory listening devices in court. She have noticed that many witnesses, I'm sorry, not witnesses. She has noticed that the defendants are often listening to devices, and unless they had some type of motion for her to hear or reasoning for that to be going on in court, then they're going to kind of, you know, move that on out of the practice. And so one attorney, no one had any really objection. Someone said that it was because they was bored. She was like, well, they won't be bored anymore because we're moving forward and we're going to move forward swiftly. And one attorney said, well, he uses that time because he gets limited time with his client. So he uses that time to kind of hear testimonies and hear different evidence and that kind of thing. She said, I would encourage you to do that after, before or after court orders, court hours. Now, something of emergency kind of presents that we need to revisit that. She was willing to revisit that, but everybody's going to be present and fully listening to what's going on in court. She wants to know how many witnesses there are to go and what are they to say. So it's said that the state has 200 and something witnesses to bring forward. Baby, she want all of that in front of her before they start, before the jurors get there and all of that. So, because we may need to whittle that down some. Not everybody's testimony may need to be heard. So the state has to produce that beforehand. I thought that that was interesting. She said there is a rule for cumulative evidence, and I may opt to use that rule. So I would need every little bit that you have in front of me before we go forward. Tempers have flared a whole lot in this case. She understands it's been a long trial. They will maintain a degree of decorum and professionalism in court. She wants a general list of evidence that need to be reviewed for items that are admissible. So both the prosecution team can submit their items that they feel like need to be admissible, and the defense team can present things that they feel like that need to be admissible or re-reviewed. For example, um, like a bunch of jail calls and Instagram posts and pages and pages and pages of that. All of that is not admissible, and some of it didn't need to be heard. So she asked that they put it all down in a bulleted item for her, and she will review it. So some of the things that Judge Glanville had ruled upon that was admissible may get taken out. Boy, the state did not look happy with all of this stuff. The judge also strongly encouraged everyone to talk to each other about any pleas that may be considered. She advised them to kind of work together and have some conversations because she's willing to even hear pleas at this time to help move this case along. If there are any agreements in lieu of trial, she would like all of that to be presented to her by Tuesday, the 30th. I kind of like this judge. I kind of liked her so far. She plans to move things along, not play around, um, hear the evidence, and follow the law. She even stated some laws that she may be required to put in place, especially surrounding all of this evidence and stuff. And I thought it was huge to get a judge to come on and say, hey, I'm willing to listen to some plea deals. Y'all talk to each other and see if you can, come up with some plea deals for people to kind of, you know, relieve themselves of this case. What that may mean is definitely that RICO, which was the big thing, would go down. They don't even have evidence of, really, evidence hasn't been presented thus far of a RICO. So anything else that is on the table may likely be time served, considering how long this case has been going on and how long these people have been sitting, because Judge Glanville kind of held tight to no bonds and not letting them out on bonds and things like that. I thought this was interesting. So the question is raised, how will this case go forward? What do we think will happen with this case? What are your opinions on what may happen with this case? For me, I am looking forward to one, I want to see if she is going to remove these DAs and listen to that motion. And she's going to listen to the motion, of course, that Brian still filed. But will she rule on that? And then is she going to honor the case law that Brian still presented today? That is huge about the recusal, because once that recusal is signed and placed, and it was, he named the judge who had signed the recusal motion. He named that judge. The thing is, Judge Glanville heard it, and he said he heard it and ruled upon it. But now that he has been recused, it kind of backs things back up to that date and everything that was listened to after that. I thought that was pretty big. So I think she sent a clear message. I think the clear message she sent was, one, she is here to stay. She's going to see this thing through, and the circus is over with. The reality TV show that has been going down in Fulton County and all of the exposure, this lady is on the bench, and we're going to see a real court go down. And I think that she will be fair. And I think that where the DA was kind of able to have their way, I don't know if that's going to be the case. They're going to have to come with it. Especially, she said by now, she would have, in a case like this, she would have already ruled on all the evidence. This kind of taking it as you go, kind of putting it in as we go, clearly that's not going to work for her, because she want to see everything that they plan to bring and every witness on what they have to say. She wants to see that beforehand. So what does that mean? They have 2 weeks. They're going to be, the next court date is going to be July 30th. They have things that they need to submit to the court for her to review before July 30th. But the next court date will resume July 30th. They're going to meet every day that week. And this will be another court date of just the judges and the lawyers just trying to get caught up to see what's going on and where they are with the case. I think they call it a status update. That's what she called it. And so on July 30th, they will meet again. Court will presume they will go over all of these items. They will work through that the entire week. And at the end of that week, she will decide if she will bring the jurors back the following week, or she will give them another week. She wants everything streamlined and in order before they proceed. I thought that was huge, guys. And Brian still did not come to play. First day of court, he's already filed a motion to have these DAs taken off the case, citing all of their unprofessionalism and rule breaking. And he also plans to cross examine them. I would love to see Judge Glanville on the stand answering to his wrongs in this case under this judge. I would love to see it. I would love to see those DAs on the stand. And Brian still getting his chance, his vengeance for his client. Can y'all tell I'm excited? I'm just excited to see it unfold. I still don't have a bias. I don't think that he is guilty of what they've accused him of. I'm getting out of all of the other things that are not in front of us that may or may not be. I'm not even talking about that. But the thing that's surrounding his case and what he's accused of, it sounds like that's going to have to be a not guilty. But I mean, I'm not an attorney. I'm just a spectator here, and I'm ready to see some real courtroom action. So, with that being said, it's your girl Duchess. Drop down in the comments to let me know what you guys think. And to all my subscribers who are really here for the TV, I apologize if this is not your content. You can also drop in the comments and let me know. So I won't torture you guys too much with this, and I'll just kind of, do my spectator things on the side. But that motion is huge. That motion is huge. And to have Lil Woody's testimony thrown out, That is huge. Does that mean that he can take his plead the fifth and be done with this thing altogether and reset it the way it's supposed to? Or will he be called to witness again? I know one thing. I will be there to watch this spectator sport go down in this YSL saga that is unfolding. Thank you to whomever has come in to listen. Um, I appreciate you guys so much. All of the support on my channel. I definitely appreciate it. Um, this is a fun space and I'm enjoying the lane for sure. I have a couple shows that I'm going to be reviewing that will be coming up. We'll add to the lineup. So your girl is working hard over here in these YouTube streets to bring you guys quality content. And as always, I am open to your feedback as I grow this channel and hopefully give you some good entertainment at a minimum. Thank you so much for popping in. It's your girl Duchess, and I am out.